Welcome to Chapter 3, where we will focus on the penalties for non-compliance under the Digital Personal Data Protection Act 2023. One of the central aspects of the Digital Personal Data Protection Act 2023 DPDP Act is ensuring that organizations handling personal data comply with strict privacy and data protection standards. The Act introduces penalties for non-compliance to deter violations and enforce accountability. This chapter focuses on the penalties for violations under the DPDP Act, including the calculation of penalties, factors influencing penalty decisions, and how the penalties are structured. Penalties for noncompliance, Section 33. New provisions for penalties. Section 33 of the DPDP Act outlines penalties for noncompliance, and with the recent amendments, there is a stricter penalty framework in place. Data fiduciaries and data processors who fail to comply with breach notification timelines or fail to implement necessary security measures may face penalties of up to 250 crore. For instance, if a company fails to notify the Data Protection Board or the data principals about a data breach within the required 72-hour window, the company could be fined up to 200 crore depending on the severity of the breach. This is a significant penalty, and it underscores the importance of timely breach notifications and robust data security practices. Example: imagine a company that has suffered a data breach and the affected individuals are not notified within 72 hours. The fine imposed could range from 100 crore to 200 crore based on how severe the breach is and how many individuals are impacted. Increased enforcement and audits. New requirement: the DPDP Act now mandates regular audits of significant data fiduciaries to ensure compliance with data protection requirements. Example: a large social media platform that processes sensitive data must undergo regular audits to ensure compliance with data protection laws, including DPIAs and breach notifications. Understanding the penalties for violations. The DPDP Act establishes a structured framework of penalties for data fiduciaries, data processors, and other involved parties who fail to comply with the provisions of the Act. These penalties are designed to ensure that personal data is handled responsibly and to safeguard individuals' rights. Key provisions under the DPDP Act regarding penalties. 1. Failure to adhere to data processing principles. If a data fiduciary or data processor processes personal data in violation of principles such as lawful processing, data minimization, or purpose limitation, penalties may be imposed. For example, if personal data is processed for unauthorized purposes or stored for longer than necessary, penalties can be triggered. 2. Failure to comply with consent requirements. Section 6 of the DPDP Act highlights the necessity of informed consent. Non-compliance, such as failing to obtain valid consent from data principals or violating consent conditions, can result in severe penalties. This may include cases where the data is processed without proper consent or the consent mechanism is unclear or misleading. Failure to notify data breaches. Under Section 8.6, data fiduciaries are required to notify both the Data Protection Board and affected individuals about data breaches within a prescribed time period. Failing to do so could lead to penalties, especially if the breach puts individuals at risk of significant harm. Non-compliance with data protection obligations. Data fiduciaries are responsible for implementing security measures, appointing data protection officers, DPOs, and adhering to data processing audits. Failing to comply with these obligations can lead to significant fines under Section 33. Penalties and enforcement. The penalties for noncompliance are specified in Schedule 1 of the DPDP Act. The Data Protection Board of India, DPB, has the authority to impose penalties after a due inquiry depending on the severity of the violation. Calculation of penalties, monetary penalties. The calculation of penalties under the DPDP Act depends on the nature of the violation, the impact on the data principal, and whether the violation was repeated. Let's break it down into categories. Minor violations. Minor violations, such as failure to notify the data principal or slight delays in obtaining consent, may result in fines ranging from 10 lakh to 50 lakh. The severity of the penalty depends on the specific circumstances surrounding the infraction. Significant violations. More severe violations, such as unauthorized processing of sensitive personal data or experiencing a large-scale data breach can result in penalties as high as 200 crore. These violations could include failing to implement adequate security measures or sharing data with unauthorized third parties. Severe violations. Severe violations, especially those involving gross negligence or repeated non-compliance, can lead to penalties up to 250 crore. The penalty amount will be based on factors such as the number of people affected, the seriousness of the violation, and how long the non-compliance persisted. Example: if a telecom company fails to notify the Data Protection Board within the required 72-hour period after a data breach, it could face a penalty of 200 crore based on the severity of the breach and the number of affected individuals. Factors influencing penalties. When determining the penalty amount, the Data Protection Board considers several important factors that reflect the seriousness of the violation. The goal is to ensure penalties are proportionate to the harm caused while incentivizing compliance with the DPDP Act. Key factors influencing penalties: nature, gravity, and duration of the breach. The scale and severity of the breach are crucial in determining the penalty. A breach involving highly sensitive data, such as health records or financial data, will attract a higher penalty than a breach involving less sensitive data. Similarly, if the violation continues for an extended period, the penalty may be adjusted upward. Type and nature of data affected. The sensitivity of the data impacted by the breach is also a key factor. Breaches involving sensitive data, such as health information or financial records, will result in higher penalties. Repetitive nature of the breach. Data fiduciaries with a history of violations may face aggravated penalties. Repeated violations indicate a failure to maintain an adequate level of compliance, and the board may impose stricter measures to enforce compliance. Gain or avoidance of loss. If the data fiduciary or data processor benefited from the breach or avoided significant losses due to the violation, this can affect the penalty amount. For example, if a company gained profits by improperly processing personal data, those profits may be considered when calculating the penalty. Mitigation efforts. If the violating party takes prompt corrective actions to mitigate the effects of the breach, such as notifying affected individuals and implementing stronger security measures, the penalty may be reduced. The timeliness and effectiveness of these actions play a crucial role in determining the final penalty. Impact on data principal. The harm caused to the data principal will also influence the penalty. If the breach results in identity theft, financial loss, or emotional distress for a large number of individuals, the penalty will reflect the impact. Example of penalty calculation. Let's look at some practical examples of how penalties can be calculated. Scenario 1. A real estate company processes personal data of customers without obtaining proper consent. Additionally, the company fails to implement adequate security measures, resulting in a significant data breach. Penalty calculation. Nature of breach. Unauthorized processing and inadequate security, medium severity. Type of data involved, sensitive data, including financial information and identification details. Duration, ongoing violation for several months. Penalty, 150 crore, medium high-level penalty based on severity and duration. Scenario 2. A global e-commerce company processes sensitive data without clear consent and suffers a massive data breach that affects millions of individuals worldwide. Penalty calculation. Nature of breach. Unauthorized data processing and a massive data breach, high severity. Type of data involved. Sensitive financial and personal data. Repetitive violations, prior history of non-compliance. Penalty, 250 crore, the maximum penalty for severe violations. Key takeaways. To summarize, here are the key takeaways. Penalty framework. The DPDP Act outlines a structured penalty framework where fines range from 10 lakh to 250 crore, depending on the severity of the breach. Factors affecting penalties. The penalties are influenced by factors such as the nature and gravity of the breach, the type of data involved, and the duration of the violation. Mitigation efforts. Taking prompt corrective actions to mitigate the breach can reduce the penalty. Repetitive violations. Recurring violations lead to harsher penalties. By understanding these provisions, data fiduciaries can better ensure compliance with the DPDP Act and avoid significant fines. In the next chapter, we will look at legal redressal and appeals under the DPDP Act, including how data principals can seek redress for violations and the appeals process. Thank you for engaging with this chapter on penalties for noncompliance. Stay tuned as we dive deeper into the redressal mechanisms and the role of appeals under the DPDP Act. Thank you for joining this session. In the next lesson, we will explore the legal redressal and appeals, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/@prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.